and I'll be guiding you through today's panel. I'm a lawyer, but I'm also the director of the Los Angeles Incubator Consortium. If you know us, we support solo lawyers who are committed to making legal services more available in communities that are underrepresented due to all of those factors, economic, language, cultural barriers. So as we all still enter the Zoom room, I am really overwhelmed. It's amazing at the response. As we're just sort of waiting for people. I also wanted to mention, if you haven't seen this article in today's LA Times by Jenny Gold, it is really well written, really heartbreaking. It's called "I Already Want to Cry: Undocumented Parents Prepare for the Unthinkable, Giving Up Their Kids." It's really well written and it gives a good picture of why we're all here, the high stakes that have brought us together. Again, thank you for joining. Again, we are coming together today as we let everyone in. People are still coming in. We just want to reaffirm our commitment together to becoming the fabric of a safety net for our friends, allies, neighbors, everyone who's suffering right now, unimaginable fear. And I know each one of you can help us build a structure, a community, and continuity of care that if temporary separation happens, we're going to just keep on making a solid and safe community so that we can reunite people as soon as possible and so that nobody is alone. So before we start, and please do mute yourself, I just wanted to thank Lou Serrera for putting this panel together. She's a lawyer, law professor, co-founder of both Community Lawyers, Inc. and the Los Angeles Incubator Consortium. Lou did some heavy lifting today, organizing this panel and bringing the training to life. And she's also been reaching out to do a lot of organizing to me and a lot of you in LA and Orange County. And I do hope that the relationships we're building we're going to be forming them and working together on projects for many, many years to come. And briefly, thanks to our speakers, Michelle Mendez, Lisa Ramirez, Pablo Palomino, Teresa Gutierrez, and Walter Quinteros, as well as our host, San Fernando Valley Bar Association, both Lisa Temkin, who is handling all of this presentation details, and of course, my very good friend, Seth Chavez, the executive director of San Fernando Valley Bar Association, who embodies both wisdom and compassion for all of us lawyers in the region, and more importantly, there's Seth, for the clients who really, really need our legal services, whether or not they have the money. So Seth, please say a few words.
Awesome. Thanks, Maria. I won't restate the excitement of this program and so forth, but very excited about this. I'm Seth. I'm the executive director of the San Fernando Valley Bar. The SFVBA is super proud to host this training, provide resources, host the panel of attorneys that's coming up. We're determined to make this effort meaningful and impactful as a bar association. Some really quick housekeeping. If you have any questions along the way after this presentation, or you want to know more about the panel, you need to be directed to someone. You can use info@sfvba.org. I'll put that in the chat for later. And we have a resource page on our site with links to documents that will be mentioned during this presentation. We'll get that into the chat as well. This program is staffed and has technical resources, including pre-screening members of the public for these pro bono and low-cost referral panels that we're going to have. If you'd like to support this program, just become a member of the SFVBA. If you're not really interested in that, you can just turn off your emails if you like, though I'm sure a lot of the benefits of SFVBA are relevant to attorneys throughout California. Corporate and law firm support inquiries can go to info@sfvba.org also. Otherwise, just want to say it's an open door policy. I'm not hard to find. If you have ideas for us, if you have questions about the panel or the program or how to get connected, how to contact someone, what else you can do, or how you can support this program, feel free to reach out to me. And I'll just leave it at that and pass it on to our presenters.
Great. And I will go ahead and introduce our first amazing presenter, Michelle Mendez. Michelle has devoted her legal career to serving immigrants and refugees. She serves as the National Immigration Project's Director of Legal Services and Training, where she oversees the training, legal resources, and technical assistance curriculums, supervises the motions to reopen project, and engages in litigation. She's won numerous awards for her amazing work, and I'm so happy to pass it on. Oh, sorry, I forgot the agenda, but this is Michelle right here.
Thank you so much, Maria. I really appreciate you. Appreciate Seth and Luz, of course, and the other panelists. So we want to start off by laying the context of what is happening right now. And before I get into that context as to why it is that we need to have family planning and help immigrant families, just want to give a quick overview of our organization. This is the National Immigration Project. This is not all of us, but this is most of us. We are a membership organization of attorneys, advocates, community members who fight continuously for a compassionate, welcoming, humane immigration system. We have that vision. We hope that we will obtain it at some point. We litigate, advocate, educate, and build bridges across movements. And we have just a bunch of different members as part of our membership. We have nonprofit organizations, small and medium-sized firms, individual solo attorneys, you name it. And so with that, let me go ahead and go to the next slide. All right, so again, we want to now talk about the general background on the immigration removal system. And so before discussing ICE's specific enforcement tactics and understanding the context that gives rise to the need for family planning, we really need to have this general understanding of the immigration removal system because it's not entirely logical and it's just easier to understand why ICE might be doing what it's doing, understand the context and who is involved in this whole removal system. So there are two agencies that are involved in this removal or deportation system. Let me take a quick moment real quick to just ask those of you who are not muted to just mute yourselves when you get a chance. It's for the Afghan Legal Services Project. Yourself when you get a chance. Thank you so much. All right. So the two agencies are the Department of Justice and the Department of Homeland Security. You want to note that both agencies are housed within the executive branch, right? Neither of these is housed within the judicial branch, even though we have what's called immigration courts that I'm about to talk about. So both are within the executive branch. So we've got the Department of Justice, which administers the immigration courts and the Board of Immigration Appeals. This means that immigration judges and appellate immigration judges at the Board of Immigration Appeals work for the Attorney General. Then you've also got the Office of Immigration Litigation, which is responsible for coordinating immigration matters before the federal district courts and the circuit courts of appeals. What does this mean? For example, if somebody gets beyond the Board of Immigration Appeals, so somebody loses before the immigration judge and then they appeal to the Board of Immigration Appeals, they can then appeal to the Court of Appeals. They can do a petition for review with the Court of Appeals, and that's where the Office of Immigration Litigation comes in. That's who represents the government at that stage. So then we've also got the second agency, which is the Department of Homeland Security, and that's who we really are focused on right now. So this agency, just so you know, this hasn't been around for a long time. This hasn't been embedded in the foundations of our creation as a country. This agency was created in 2002. So it's a relatively new agency. And this agency has several components. The two on which I want to focus are Immigration and Customs Enforcement and USCIS. I'm going to talk about USCIS later. But ICE consists of the Office of Principal Legal Advisor. We call that agency OPLA. OPLA, just that means that these are the folks who represent the Department of Homeland Security in immigration court. So they are the prosecutor, if you will, in immigration court. You also have enforcement and removal operations. So this is the component that has those ICE agents who carry out arrests and removals. You also have Customs and Border Protection, which by its name tells you that they are located at borders, right? Ports of entry or borders. All right, so these are the two agencies that are mostly who are the big players in this removal system. Let's go on to the next slide. And there's two different processes. So both the Department of Justice and the Department of Homeland Security have statutory authority to order the removal of a non-citizen from the United States. You've got the Section 240 of the Immigration and Nationality Act. So the statute that we're working here with is the Immigration and Nationality Act. So Section 240 of that's where we get the authority for immigration judges to order non-citizens removed, to deport them, to order the deportation. And this is an adversarial process in an immigration court where the non-citizen has various rights, including a reasonable opportunity to present evidence on their own behalf. And non-citizens in removal proceedings before an immigration judge, they may be detained or they may not be detained, and they can also appear in person or they can appear virtually. Then you've got this other framework, this other statutory framework, which is under Section 235 of the Immigration and Nationality Act. And under that provision, DHS officials have the authority to issue expedited orders of removal. This is an interview process where the non-citizen has very few rights, very limited rights, and they are detained throughout this process. And the decision maker is DHS. So here in this process of expedited removal, the jailer is the adjudicator. There is no neutral party. There is no hearing. So just me talking about these two agencies and these two processes, we know that it's much more preferable to be in a removal proceeding before an immigration judge than it is to be in expedited removal. Even if that immigration court, even if that immigration judge is under the executive branch, it is much more preferable. So if you're wondering why ICE has been ambushing non-citizens at their immigration hearings, it's because ICE, through its attorneys, is seeking dismissal of the immigration hearing so that the immigration court no longer has jurisdiction over that person's case. That case is terminated. And once the immigration judge dismisses the case, ICE agents are outside waiting to detain the person and then place them in expedited removal. So they are taking them out of 240 proceedings before an immigration judge and putting them in this much less preferable system that is expedited removal. And again, they are detained. All right, let's go on to the next slide. So now you're probably wondering, what is expedited removal then? Tell me more about that. What can we expect? So let's look at the traditional understanding of expedited removal. It's important to know that the use of expedited removal has actually varied since it was adopted in 1996 through legislation. And now, until now, it has not been fully implemented. So the statute offers one particular system of expedited removal or says something about expedited removal, but until now, that has not been fully implemented. It has been implemented in parts. So the Trump administration has taken the full liberty to go ahead and use its full statutory authority to implement expedited removal. And so the expedited removal statute, what is that statute? Not the actual implementation, not how it's been adopted since 1996, but that expedited removal statute that says on its face that non-citizens who arrive at a port of entry, such as an airport or a border crossing, without a valid type of entry document, and who are found to have used fraudulent documents to enter the United States, that those groups of people who have entered without valid documents or who have been found to have used fraudulent documents, that's what it applies to, right? Those two groups. That expedited removal also applies to some non-citizens who entered without inspection and who have not been continuously present in the United States for at least 2 years. So that's what the expedited removal provision of the statute says. And expedited removal primarily applies to individuals who arrive at a port of entry like I said before, like an airport or a border crossing. All right. But again, they have to have not had valid entry documents or have been found to have used fraudulent documents. All right. So I think I've covered that sufficiently. Is there a way to get out of expedited removal? That might be your next question. And instead get into removal proceedings. So yes, the answer is yes, there is a way to get out of expedited removal and into removal proceedings if the non-citizen expresses a fear of return to their country of nationality and they pass a credible fear interview. Once a non-citizen passes a credible fear interview, then that expedited removal order is canceled and they are then referred to the immigration court. So somebody who gets placed in expedited removal at the border, at the port of entry that I was just talking about, they can go ahead after that, get out of that expedited removal process and into immigration court proceedings, which is much more favorable to that non-citizen. All right, so that's kind of the traditional understanding and the statutory understanding of expedited removal. But again, that hasn't been fully implemented. Expedited removal hasn't been fully implemented until now. So it had been implemented in parts, like very softly until now. So let's go to the next slide. And what's important to know now is that ICE is interpreting expedited removal in a much more expansive way than we have ever previously seen before or agree with. So in my view, in our view, those of us who practice in this work, who are in immigration law, we think that ICE is going way beyond the statute, which I just talked about. So under ICE's interpretation, expedited removal applies to anyone who entered via parole at a port of entry, even if the Department of Homeland Security then revokes that parole. If they entered the United States without permission and have spent less than 2 years in the United States, then expedited removal applies to them. If they entered the United States without permission and they were initially arrested within the 2 years of entry, even if they were later released and have now spent more than 2 years in the United States. So ICE, yes, if you heard that right. So if they entered the United States without permission and they were initially arrested within 2 years of being in the United States following that entry, later, even if they've been now here for 20 years, 15 years, however long, it's the fact that they were initially apprehended, arrested within the 2 years of entry that keeps them subject to expedited removal forever. The same thing with those who entered via parole at a port of entry. ICE is saying that those folks are forever subject to expedited removal. And it's really important to know that the Biden administration, they used their parole authority to vet and to legally welcome a lot of different groups. You have Cuban, Hondurans, Venezuelans, Haitians, right? You've got different parole programs, including United for Ukraine, just to highlight that the Biden administration really used its parole authority to welcome different groups. And it's also really important to know that parole at the border, release at the border, and told to report to ICE, these are all things that are on the slide. These are all mediums by which the Biden administration allowed people to come in through the border. So what we're seeing right now is that the Trump administration is applying expedited removal to a larger group of people than before. And these are people who our country previously knew about and welcomed. All right, so let's go on to the next slide. So who does expedited removal not apply to? You may be confused about who it does apply to because I talked about the statute says one thing, but then we implemented it halfway or in little bits and pieces along the way until now. But then now the Trump administration, we feel, is going way above and beyond its authority. So it may be easier to understand to whom it does not apply. It does not definitively apply. And so it does not apply to U.S. citizens, to lawful permanent residents, to those who entered on a visa, refugees and asylees, people who are currently in removal proceedings in immigration court. And this is really important because of the ambushes that are happening in immigration court. So again, they're getting dismissal of the case and then they are detaining the person. So you cannot have somebody who is simultaneously in what's called, or simultaneously before the immigration judge, but also in expedited removal. So that's why they're going through the process of getting the case dismissed. The person thinks, the non-citizen thinks, oh, this is great. My case is getting dismissed. I don't have to come back to immigration court. Meanwhile, they go outside and they get detained and placed in expedited removal, which is way worse. It also does not apply to people who have a final order of removal already. If they have a final removal, it's done. They don't go through this process. What ICE does in that situation is just quickly remove the person who has a removal order already. They will not give that non-citizen the opportunity to see any type of adjudicator at that point. It does not apply to unaccompanied children, those who entered the United States and were determined to be unaccompanied children. There's a lot that I could say about this, but I know we want to keep going. But if you are thinking about who is an unaccompanied child, you can feel free to reach out to me after this presentation. So let's go into the next slide and let's look at the current ICE enforcement tactics. So you now know how the removal process works, who's involved in the removal process, and then expedited removal and how the Trump administration is really using this against people. But let's look at just more generally ICE tactics. So in terms of apprehensions, it's important to also know that there's quotas. There's quotas that are 3,000 people, arrests for 3,000 people per day per ICE ERO office. And then when you have quotas, this leads to unlawful arrests, including those that have Fourth Amendment violations. And you all know this in Southern California because of that TRO that was just handed down because of ICE basically detaining people without probable cause and just going after people who look a certain way, and then turns out that they're citizens or lawful permanent residents, et cetera. So quotas lead to unlawful arrests. It also, like I said before, we already talked about the expansion of expedited removal and how important it is to understand what that means in relation to removal proceedings in immigration court. But also know that these ambushes are not just happening in immigration court, they're happening also at asylum offices, also at USCIS offices. Expansion of those who are vulnerable to arrests. So collateral arrests, if ICE goes for a particular person in a home, and then they find people who are undocumented there, they are going to pick up the other people who were undocumented there, but they weren't necessarily looking for initially. And that's all part of what the quota is driving. And then they're also picking up people who have things like protections such as temporary protected status, and those who have cases pending in immigration court. They'll just go ahead and detain them, and then the ICE will say, well, if they're eligible for a bond, they can seek a bond. At least we're meeting our quota. Apprehension of pro-Palestine protesters, including lawful permanent residents. I'm sure you all have seen the news about this, including one gentleman who went for a naturalization interview. They're also partnering with a component of Department of Homeland Security that I did not talk about before, but it's called Homeland Security Investigations. They tend to focus on like trafficking and a lot of these kind of special cases. But they've partnered with that component, Homeland Security Investigations, to conduct supposed wellness checks of unaccompanied children. And so they're going to the homes of unaccompanied children and doing this check, where I actually think what they're doing is fact gathering so that they can come back and place the sponsors or the children themselves in detention. And we obtained a memo through FOIA that shows that they also intend to bring some criminal charges where possible against the sponsor of the unaccompanied child or the unaccompanied child. And then we also have expansion of immigration enforcement to other agencies, including state and local enforcement. So lots of new, what are called 287G agreements, cooperation with local law enforcement, and just basically delegating their authority to detain people wherever possible. And again, this is driven by the quotas, because if they delegate their authority to someone else to get more people, then that also makes it easier on ICE to not have to fulfill that 3,000 person quota on their own. And then expansion of arrests to previously protected locations, which include churches, hospitals, schools. And so this really disrupts the community and the ability for people to function in a normal way, take their kids to school, go to church, etc. Let's go on to the next slide. So I just talked about apprehensions and kind of the tactics and the driving forces behind those apprehensions. And then now I just want to touch briefly on the detention and removal piece. So once the person is apprehended, what does the detention and removal look like right now with today's ICE? So they have restarted family detention. So this is a detention facility for parents and for children. This was something that I worked on a lot during the Obama administration. Got rid of it, did not come back for a while, and now it's back, very unfortunately. And then we also have seen detention in Guantanamo, contracting with Bureau of Prisons, this new Everglades facility where access to counsel is limited or non-existent. Luce actually sent me a story the other day about how there was a DACA-mented person who was believed to be detained at that Everglades facility. And so what's difficult about these locations, these places where people are being housed, is that we don't know where they are. We don't know how to find them. We don't know how to advocate for them if we don't know how to find them. We also see overcrowded and otherwise really inhumane detention conditions where people are jam-packed in a cell, in a cage, where they have to share one toilet. And these are really conditions that we would imagine seeing in asylum cases, in those types of cases where people are fleeing that type of torture. We're now seeing that people are being subjected to those types of conditions, and that's that type of treatment here in the United States. We also have seen baseless Tren de Aragua, that's what that acronym stands for, TDA, Tren de Aragua allegations against Venezuelans. And of course, the invocation of the Alien Enemies Act to try to remove Venezuelans without due process to Secot in El Salvador. This is yet another detention facility where the person gets sent and they are incomunicado. We have no way of getting access to them to know how they're doing. And we know from Mr. Abrego Garcia, who recently returned to the United States, that he was subjected to terrible torture. And so we assume that there were horrible things happening in Secot, and he just confirmed them when he came back recently. We're seeing removals to third countries of those non-citizens who won withholding of removal or Convention Against Torture Protections, which are forms of relief that are not as protective as asylum, but they're supposed to be protective against your own country, so the government cannot deport you to your country of origin, but they can deport you to other countries. So the Trump administration has done that and entered into agreements with other countries to send people to. We also have seen that the ICE acting director has implemented a policy where he has to review every case before releasing the person from detention. So this has led to prolonged detention. And we also are seeing that there's no more discretionary decisions to not detain a person or to release the person and to adjudicate and approve the stay of removal of the person. So in other words, whereas before ICE had prosecutorial discretion to release a person or to not detain the person or to stay the removal of the person, that prosecutorial discretion has been taken away from ICE. And if a person wants to get released from detention, they have to seek a bond or they have to go the habeas route. Let's go on to the next slide. All right, so how are other executive agencies aiding and abetting ICE? Let's go to the next slide, please. So DHS is USCIS. This is the agency that I talked about before, one of the components of the Department of Homeland Security. This is the agency that adjudicates benefits. So I'm not going to go through all of these one by one because I want to make sure that we have time for everybody else's really wise words that they're going to be sharing with you. But just see what USCIS has done. And basically, if you were to get a theme out of everything that's on this slide, is that they are either taking away or delaying people's legal status in the United States. And again, these are people who entered on parole through one of the many programs that the Biden administration had in place. So what does that mean? That the person no longer has protection from ICE, that the person is going to get detained more easily by ICE if you take away their legal status, their legal protections. And we are also seeing here where USCIS is pre-terminating or pre-terminating asylum applications of people who have an asylum application pending, also for the purpose of allowing them to get placed into expedited removal. So it's not just the immigration courts, it's also USCIS, but to a lesser extent, is my understanding. Let's go on to the next slide. DOJ's EOIR. So EOIR is the Executive Office for Immigration Review, and the immigration courts and the Board of Immigration Appeals are both under this agency, under the Department of Justice. And so what are they doing to aid and abet ICE in ICE being able to detain and remove people? Well, immigration judges are granting ICE's, remember, the ICE attorney is part of OPLA, Office for Principal Legal, yeah, OPLA. And so they are granting ICE's motion to dismiss to allow the initiation of expedited removal. ICE is also granting ICE's motion to recalendar, thereby forcing non-citizens to face an order of removal. What does motion to recalendar mean? It just means that the person ended up getting the case administratively closed. That case was hibernating. And then they were just kind of waiting around for something to become ripe, let's say with USCIS, some benefit before USCIS that there was a backlog on. Well, that case got administratively closed to allow USCIS the time to process that application, that benefit, or whatever. And then now what's happening is that ICE is doing motions to recalendar to make those cases active again. So if those cases are active again, but there is no benefit that is ripe yet before USCIS, what the immigration judge is going to do is order removal, unfortunately. And then they're issuing new policies to allow the immigration judges to pre-terminate asylum cases without a hearing. They're also firing immigration judges every week. They actually fired Board of Immigration Appeals members hired during the Biden administration and have since, so basically everybody who they hired during the Biden administration is gone. And so they have just the Board of Immigration Appeals members who were hired during Trump and before, the first Trump administration and before. And to kind of fill that gap, they have hand-selected immigration judges to temporarily replace them. And the BIA is issuing precedential decisions every week that make it harder for non-citizens to win relief or to obtain release on bond from immigration judges. So I just mentioned to you that USCIS is doing their part, unfortunately, to take away or delay legal statuses or legal protection. And that makes it easier for ICE to then detain people. Well, and then at that point, if they're detained, they have to seek a bond because, again, they're not exercising their discretionary authority, their prosecutorial discretionary authority to release people. So they have to look for a bond or potentially for habeas. But what the Board of Immigration Appeals has done is made it more difficult on the bond side. For example, they issued this decision called Matter of Q Lee. If you can't read that well, that's the Q.Lee, L-I. And I put the link, which you'll get on the PDF of the slides. Let's go on to the next slide. So I wrap up here. Okay, so what do we need to know about bond and about detention? So as you're probably gathering, immigration is very statutorily oriented, right? There's a lot of statutes that we should be looking at and have to look at. And so there's some detention statutes that, just to give you a very broad overview, we've got 236A, which is the general discretionary detention authority for those in immigration proceedings. So if somebody falls under ICE's detention authority under 236A, then they are eligible for a bond hearing. If somebody falls under 236C authority, then there is no bond detention, no bond, and their detention is mandatory, rather, because of certain criminal history. So 236C, there's no bond, there's mandatory detention, usually because of criminal issues. If you're detained by ICE under Section 241A of the INA, then you do not get a bond because you have a final order of removal. So you already have a final order of removal, whether that was a prior expedited order of removal or an order by an immigration judge. So this, for the longest time, up until now, we were functioning under the impression that, and the understanding that, if you did not fall under 236C because of some criminal history issue, or you did not fall under 241A because you didn't have a prior order of removal, then by default, you fell under 236A and you were eligible for a bond. Because of a lot of reasons, which I'm not going to get into right now, we now have, unfortunately, 235 in play. And 235, remember, is the statutory authority for expedited removal. So 235B1, that says you don't get a bond because you are subject to expedited removal. Right. So you are going through the credible fear process. You don't get a bond because you're in that situation. But then now we also have 235B2A, which is the detention authority for those who are arriving. They're called arriving non-citizens. So not placed under expedited removal, but arriving at the border. And because of that statutory authority, 235B2A, matter of QLE has made it so that more people are getting brought into that provision, that last provision on the slide. And again, that provision on the slide is very negative. It's very unhelpful. It's very prejudicial because it's mandatory detention. So what's happening now, even as of last week, ICE is taking the position that unless you entered with a visa, you were admitted with a visa, you are subject to 235B2A detention authority and you are not bond eligible. So they're continuing to push this. Then, like I said, the Board of Immigration Appeals issued matter of QLE, pushing more people into that last category on the slide. And now, as of last week, ICE's position is that no, if you entered with a visa, are you eligible for a bond hearing under 236A? Everybody else, if you're not subject to 236C because of a crime or 241A because of a final order, then the default is 235B2A. And this is super, super bad, as you can imagine, because you don't get access to a bond. And so how do you get out of detention? You have to actually win your case in order to get released from detention. Let's go on to the next slide. This is just a matter of QLE so that you can take that with you. But again, like I said, things have already shifted since last week. And it was reported yesterday in the Washington Post, and I think by Reuters, the position of ICE that I just mentioned. So this is an evolving issue and a very unfortunate one that we're going to have to fight. Next slide. What can we expect in the future? Let's look at that next slide. Well, that so-called one big beautiful bill, like you can't even, one big beautiful act. I have a hard time saying this, as you can see, and also at 7 p.m. my time here in Baltimore, so apologies. But this has an enormous amount of money that is going to ICE. I will let you read that at your own leisure. Let's go on to the next slide. More money, but I want you to focus on those last three bullets. Also, everybody's focusing on the amount of money that ICE is getting, which is preposterous, I know. But the last three bullets on this slide are important. This big, beautiful bill act or whatever, this has new and increased fees for immigration benefits filed with USCIS and the immigration courts. For example, a motion to reopen went from $110 to $900. An appeal to the Board of Immigration Appeals went from $110 to $900. Asylum, for the first time in our country's history, we are charging people money to apply for asylum. It's $100, but it's $100 nonetheless. If you have nothing, that's a lot. New penalties for non-citizens with in absentia orders who are apprehended by ICE, and new penalties for inadmissible non-citizens apprehended by ICE between ports of entry. So those are some the new fees or increased fees as well that this new legislation brings. Let's go on to the next slide. More legislation, perhaps, I hope not, but we've already seen before the one big beautiful bill or one big beautiful act, whatever, Again, I have a hard time with that name. We had the Lake and Riley Act that was signed into law on January 29th. And what did that do? That brought more people under 236C mandatory detention authority. That created more crimes that made people subject to 236C mandatory detention authority. And then just recently, the House passed this bill on July 26th, where one DUI makes you inadmissible or deportable. Very important for those who are seeking, whether or not this bill becomes law, which we hope it does not, but very important. Lisa's going to talk about a lot of important things next, but she wanted me to make sure to note that lawful permanent residents, no one is really kind of safe right now in this current regime, but very important that lawful permanent residents know that if they travel, if they have a prior criminal history and they travel, that's really bad. They should talk to competent immigration counsel before they do so, because when they come back, they may be placed in removal proceedings in front of an immigration judge. So be very careful if you're a lawful permanent resident, because they are also going after you, or lawful permanent residents in general, in this situation. The easiest situation that they will come to the attention of ICE is when they travel and seek to get back into the country. Let's go on to the next slide. And here's just a slide with additional resources that you can get from us at the National Immigration Project. I want to thank you so much for your attention. I apologize that it's so late in the day for me and that I am in need of coffee. And I really, really thank you so much for everything that you're doing. And I'm going to turn it over to Lisa. Is that right?
Yes, I'll go ahead and do a well, first we want to say thank you, Michelle, because you are on East Coast time and you're doing such amazing work. So thank you for being with us and giving us that really thought-provoking and scary presentation. So our next, let's see, where is Lisa? I can't, we have a lot of people on here.
I'm here.
Can you hear us? All right. Okay, well, let me.
I don't know if you can see me and hear me, but I can hear you.
We can hear you. We can hear you. So yeah, I did want to give a little intro of you, Lisa. Lisa is the California State Bar Immigration and Nationality Law Specialist, and notably one of the first women and the first Spanish-speaking immigration law specialist in Orange County. Her practice focuses on DHS I-9 investigations and audits, establishing compliance programs for companies, and obtaining various visas for professional athletes, artists, and religious workers. She also supports family-based immigration through petitions and waivers, naturalization and removal, deportation defense in federal immigration court. Lisa, welcome.
Thank you, Maria. And thank you, Michelle, for just doing such a thorough job in covering kind of the nuts and bolts of removal. I know probably a lot of you feel like you're drinking water from a fire hydrant right now. It's a lot of information to take in. Even after practicing for 25 years, I don't know everything there is to know. So I just want to acknowledge and commend you all for taking the time at a late afternoon to be here. And it is so important, and appreciate, the Bar Association and Southwestern Law School for just hosting and putting this panel together. The reason why, we're gathered here today and why this is important, obviously, because the existing climate of this administration and its enforcement efforts. But I think it's really important. I think most of the attorneys probably on this call or the attendees are from California. So I wanted to just kind of give some perspective of kind of where we're at right now statistically and what we can expect going into the future. So it may be surprising or not to some that 22% of the immigrant population nationwide live in California. And 27% of the population in California, which is about 10.6 million people, are foreign born. That does not mean that they're undocumented. It does not mean that, they're in temporary status. These are just people. They could be naturalized U.S. citizens. They could be lawful permanent residents. They can be in a variety of different statuses. But it is a large number of people that are here, in California. And then there's about 13.7 million people living in the United States without full legal status. So that's nationwide. And of that 13.7, 2.6 million live in California. So it is a big chunk of people. And then those of you from LA, Orange, Riverside, and San Bernardino County, 1.44 million of that 2.6 million are here in those four counties. What really keeps me going, to be honest, is the kids. And it's important to keep in mind that almost half, 45% of California children have at least one immigrant parent. And there's 1 in 5 children, so 20%, that live in mixed status families. What we mean by that is that, parents, one could be a US citizen, the other could be undocumented, one could have status, the other one could not have status. And almost all of these children are US citizens. So it's super important that we're aware of just the magnitude and the focus California will be for this administration. Next slide. So here are some of the challenges, and I don't think I really need to probably tell you some of these, but obviously our communities are living in terror. I used to say they were living in fear. The fear has escalated so much. I really think this is really a COVID take two, where people are not wanting to go to work. They're not going to church. They won't go grocery shopping. School districts are being prepared to go remote for the families that need that, because parents don't want to even send their children to school, and especially if their children don't have status. Because as we've seen and read on the news, there's no discrimination when it comes to arresting, apprehending, shackling, human beings. Their age means nothing to this administration. There's obviously a tremendous amount of anger, anxiety, fearfulness. There's complex immigration and economic concerns. There's food disparity. There's people trying desperately to get access to legal assistance and pro bono help. We know all of our nonprofits are inundated and overwhelmed and really don't have capacity. So part of the purpose and intention in hosting this training is to hopefully inspire, some of you to give of your time, your talent, your treasure, any one of those, to support our communities in any way that you find you may be able to do so. There's a tremendous amount of hopelessness right now and ignorance about people's ability to legalize their status. I would say that the fear has risen to a level of almost paranoia, that people don't even, they're paralyzed. They don't even want to get the legal assistance that is available to them. They don't want to take steps even though they're statutorily eligible for permanent residency. People really want to become US citizens, and then there are those that are just afraid because they're afraid that they're going to be, have their green card revoked and be removed. And then we have citizens, both naturalized citizens and US born citizens, that are also worried about being inadvertently, mistakenly, deported just by association or by the color of their skin. And then those that are afraid of having their naturalization be denaturalized with the new office that the Trump administration had opened during his first term in office, and now has reestablished and will be getting more funding to try to take folks' citizenship away. We're finding more and more, I'm going to say, quote unquote, adult children. These are 18 and 19-year-olds. And if any of you have children of that age, you realize that, the maturity level and, they're very much children still themselves, but they're being left to take care of their siblings. And sometimes I've got clients that have chosen to depart and left behind their 12, 7, 5, 2-year-olds with their older siblings. And so it's a tremendous amount of burden for these adult children to handle. Our school system will be impacted in terms of our community colleges and our institutions of higher learning, because when push comes to shove, those children will leave school to be able to go to work and provide for their families. They face a tremendous number of legal constraints, as Michelle kind of already mentioned several of those, and I feel that things are changing every day. And there's also hostility in the work environment. So we've had, situations where, HR, personnel are calling because there's threats being made to coworkers about calling ICE. We know that the political scene is we're very divided as a country on this issue. And so people are subject to a lot of different hostilities at work and fears of ICE, coming. And ICE is using tactics that we had never, ever heard of or seen before. We represent, restaurants, manufacturing, a lot of businesses. And I have one story really quick just to share where a civilian came into a restaurant and said they accidentally, backed into a Ford Escape with this license plate. And if anybody there worked there, if that car belonged to them. And sure enough, the manager went back, asked his employees, a cook went out and never came back. There was no verification. So if there's one kind of piece of advice I have, is especially when it comes for preparedness, both at the workplace and at schools and for families, verification is key. Obviously, we have our own challenges, verifying, who these officials are, whether they're ICE or whether they're third-party contractors or whether they're people who kind of take enforcement into their own hands. But it's really important that we're verifying information, at least those of us that are able, that are U.S. citizens, that it's safe to do so before putting, other folks at risk. And then lastly, there's just a great uncertainty as to the available resources and where to go to help. So one of the things that we can do, as a community and within each of our communities is really collaborate, cooperate with nonprofit organizations locally, putting together resource lists that will help our community be able to navigate where they can go for the resource that they need. Next slide. So the response, what can we do? There's a lot that can be done, and I hope we're going to get into the family preparedness in just a moment in great detail. But I wanted to throw out some additional responses and ways that I've heard different community groups and organizations respond. And if you feel like it's something that you have capacity and want to take on, again, these are just really suggestions for consideration. So first and foremost, they're really looking for people that are compassionate and can offer emotional support. But they're really not willing to work, go someplace to get that support. I would say the majority of our consultations used to be, I would say 90% of our clients who lived locally wanted in-person appointments. And I would say it's probably down to about 50%. So people are afraid to go to counseling, to schools, to churches to get the help that they used to count on. So it's important for them to have someone other than their family to turn to and listen. There's hotlines being set up, and especially for our kids or young adults who don't feel that they can really burden their parents with their own anxieties and concerns because they know that their parents are already carrying, enough of their own. And so creating hotlines, and those hotlines can be used for, kind of just safe spaces for individuals to call to have a compassionate ear to listen, those that want to respond with, food, and those that might need spiritual support. So having churches and individuals be able to do house visits for individuals who may need it. They really are looking for peace and hope. They want to know that they are safe. So that's something really critical. One of the big, I think, basic efforts that can be done is to establish signs, right? Put signs at the workplace, distinguishing between the public and the private spaces. We know legally, ICE can access those public spaces, but the more that we make very clear what defines a public and private space on our campuses, on our workplaces, it makes a huge difference. And so signs can go a long way. Being willing to provide practical, financial, psychological, and legal resources. We used to expect folks to come to us. We had considered here in the County of Orange to do like a legal service mobile unit and kind of disregarded that completely. And now looking at building teams that can respond to house calls or help people telephonically with consultations. Helping them get legal advice that they can trust, right? We know that there's a tremendous amount of fraud. And so we want to be able to put them in good hands with the best reliable legal advice that they can get. And then lastly, and perhaps most importantly, and I can't emphasize this enough, is a plan for themselves or in the event of a parent, a sibling, or a loved one is apprehended or detained. We're going to talk about powers of attorneys, but I want to just mention very practically, from my experiences, I've got clients who are detained and they don't really have close family here. They have money in the bank account to be able to, pay for legal support, but they don't have access to their bank account, and neither does anyone else. So the ability to someone else to be able to access the bank accounts they need, handle their property, it may need to, get out of a lease that they're going to be on the hook for if they're going to be in custody or detention for months, if not years, being able to sell, vehicles if they're going to need that money. So it's really important that people are proactive and ensuring that they are not the only ones that have access to this very important and valuable resource. The second piece is to really be able to give and inform a caregiver or whoever is going to be taking care of the child what their special needs might be. So having a child safety plan in place that will cover do they take medication? Do they have allergies? Do they have any special needs? Who is their physician? Really to be able to help that caregiver make that transition and, at least temporarily take the place of the parent. And then lastly is to provide the parents with documents to have their child care wishes known and carried out. I've done a number of presentations with a number of different organizations and groups. Child abuse goes up significantly when children are taken out of the custody of their parent, even if it's left with someone who the parent believed would take care of them and trust them. So we really need to be vigilant and making sure that we're doing everything we can to protect children in our community and to equip parents to have the legal documents that they need to protect their children as well. Next slide. So here are some proactive options. And again, some of you can come into play with helping with these. But first and foremost is really encouraging our community to get their case evaluated or reevaluated by a competent immigration attorney or a Department of Justice accredited nonprofit. I'll have a link at the end and you can access, the list of those organizations, but need to be very careful about going to notaries and consultants. It will allow them to gain understanding about their immigration situation and their criminal history and how that might impact their ability to legally remain in the United States. As Michelle mentioned, with this, HR bill, I believe it's HR 875 that passed, that's gone to the Senate, making DUI is a deportable offense. We're really trying to get our clients, because we hope that legislation will not be implemented retroactively. But if there's anything that people can do now is trying to get those addressed. They may not have been, advised of the immigration consequences of the criminal charge. They may be able to get it reopened, reduced to wet and reckless. So we rely heavily on our criminal defense bar to help people with what we call post-conviction relief. The other piece I just want to mention, I don't have it here because it's something very, very new, but there in the statutes, there are both criminal and civil penalties that the government can impose for individuals who fail to depart the United States after being ordered to do so. There's been a couple of cases, I think one hit the news where the government gave a notice to an individual to pay $1.2 million. Another one I know of got a notice for $300,000. So what the statute does, the civil penalties are outlined at U.S. Code 1324D, or the equivalent is the Immigration Nationality Act, INA 274D, outlines the civil penalties, and it's $500 a day for every day that someone has been overstaying that order. And then more importantly for me is the criminal penalties, and that's outlined in Title 8 U.S. Code 1253 or INA Section 243. And that allows the government to essentially incarcerate individuals who overstay that order. They can be incarcerated up to 4 years if they don't have any other like criminal offenses or deportability or admissibility grounds, but it can be up to 10 years if they do. So the mass mass incarceration project that we see unfolding before our eyes is just the beginning. We anticipate that they will fully utilize the penalties available under the Alien Registration Act as well, for people who fail to carry proof of registration or people who fail to register. So once the big beautiful bill passed and the money is going to substantially change the playing field as we know it. Super important that every individual individual, and I would say even lawful permanent residents, I've got lawful permanent residents and U.S. citizen clients that have been detained in the last month, that they have the number of an attorney, an immigration attorney ideally, but any attorney that they can call if they're apprehended and detained. The other benefit of having their case evaluated is that an attorney has their basic information in advance so that they can respond very quickly if the individual is detained. I will tell you, most of my colleagues, including our office, folks need to wait probably a week to 2 weeks, and that's even with emergency slots open and being made available for people who call same day for because someone was, apprehended that day. And then another critical piece is really please obtain passports for all family members. People have dual citizenship. They can get, even if their children have U.S. citizenship, they can get passports if the country recognizes dual citizenship. But it's really imperative for individuals to be able to travel and be reunited with their parents if that is what they wish. Next slide. In terms of the workplace, we need to be prepared. And I would say, every workplace, I think there's going to be, targeted efforts. And as in the past with certain industries, manufacturing, hospitality, agriculture, just to name a few. During the first Trump administration, I-9 audits increased by 340%. We already have, notice of inspections for some of our clients having been served. It's an entry point, right? It's a way that DHS is going to get in to find out, if there are undocumented individuals, working there, to both penalize the employer, but also apprehend those workers. There's substantial fines that employers can face for hiring unauthorized workers. So it's really important that we as lawyers are able to represent them and negotiate those fines, especially if there's no actual violation. It's really just technical violations that can add up, that really can hit an employer very hard. Super important that every employer has policies and protocols in place. It's important for two reasons. One is to make sure that, they know how to respond if there's ICE enforcement efforts on their at their workplace, that there's a chain of command as who's to be called, who's to handle depending what the need is, whether they have warrant, which they often do not, or if it's for I-9, if someone else should be contacted. But probably more importantly is that the staff and employees feel safer knowing that their employer has thought through and has a policy that they make known, and they've trained their staff to handle those types of enforcement actions. So the most important people to train, and I will tell this time and time again because it never fails, is, front desk people, hostesses, people that normally get overlooked as perhaps, unimportant, but they're critical because they are often the ones that have that first interaction. And if they do not know how to, interact with ICE, to ask for documentation, to have them wait there, or they're extra helpful and friendly and direct ICE to people that they shouldn't be doing, then it's going to put everyone at risk. And so part of the responsibility of employer is obviously to protect their employees and their privacy. So training and developing those policies and protocols are very important. Really important is the I-9 compliance, which I already mentioned. Make sure that employers have their I-9s and that they're compliant with their I-9s. And if they don't know what an I-9 is, this is the time to educate them and to help them get up to speed with that legal requirement. It's important for employers to avoid discrimination and retaliation issues. I've got employers contacting me, not sure how to, address harassment in the workplace around immigration, and they really need to handle it the same as any other type of workplace harassment that, they are afraid to do anything because then they don't want to jeopardize other employees that they may know or not know have status, and that they are afraid that they're going to call ICE. And then any workforce that has visa dependent employees, super critical to speak with legal counsel regarding travel and visa revocation risks. Next slide. And then again, these are a little repetitive, but making sure that you're familiar with the whatever existing protocol, that all employees are familiar with it. If anybody is approached by an immigration official, that they know to contact a security or the appropriate office or the manager, whoever it is that's going to take that responsibility, so a determination can be made as to how to respond. If ICE has questions about an employee, human resources is generally my advice that should be contacted, since it's an employee-related issue or concern. But employees should never, ever take matters into their own hands. They should never provide documentation, information, or access to private areas, or direct ICE to the location of the person of interest. Next slide. So here are the list of resources. I think this is also in your handouts. The first link is for the EOIR case status. Michelle mentioned that a lot of these cases are getting recalendared. What folks don't understand is that they might have been administratively closed back in 2010, 2013. I know lawyers that are getting these motions to recalendar that for people that are not their clients. People have moved, lawyers have moved, and so it's really important that we are checking online, or there's an 800 number as well that people can call in, punching in their 800, their alien number, to see if they have an upcoming hearing. Because what I foresee happening is that there is going to be a whole lot of people that are going to be ordered removed in absentia for failing to show up, and then ICE will go out and execute those removal orders immediately. The second link is a very valuable resource to help people find their loved ones that may be in ICE detention. I will tell you, the system on every level, the courts, ICE, USCIS, is extremely slow. So if they don't show up the first day, you need to try, second day, third day. There are many people, especially those at the Alligator Alcatraz facility, that are not even accounted for on this public database search. It's a little tricky because you have to search the name exactly how ICE has them registered, which may be a first name, maybe a last name. The names might be reversed. There might be a hyphen. So sometimes you have to try several different methods. But to the extent that we can help people in moments of stress to navigate these bureaucracies and systems, I think the better. The next link is for the Immigrant Legal Resource Center. They have a 19-page family preparedness toolkit that you can look at and share with those that you think might benefit. The next one is a link to the caregiver's affidavit, which we're going to talk about in just a moment a little bit more. The next link is what I mentioned before, with a list of the Department of Justice accredited nonprofit organizations, and you can search them by state and by city. The next link is for the immigrant policy tracking website. There's about, last I checked, about 363 policies that have been introduced related to immigration alone by this administration. I can't remember offhand, but there's I think couple hundred that are subject to litigation right now. So they're keeping us busy. They're keeping all policy advocates, lawyers, folks like ACLU, MALDEF, and others that are filing these lawsuits extremely busy. So to the extent you want to share your resources, please support one of those organizations that are doing this heavy, federal litigating. The next one is the Find Your Ally. This is really important for California. So anyone who is a faculty, staff, or a student of any community college has access to free legal resources, and it's not just immigration related. So if you know anyone that can benefit from that, please share that with them. And then the last two links are for the California Attorney General's office that has guidance for enforcement for higher education, and then a K through 12 model as well. So next slide. So our office is here as a resource. If we can be a tool for any of you, your local bar associations, to do any sort of trainings or presentations, feel free to reach out. And yeah, again, I just thank you for taking the time to be with us, and then I'll turn it back over to Maria. Thank you.
Lisa, thank you. You are such a fearless leader. And yeah, we're just in awe. Thank you for sharing and let us know what we can do to help you. So, on now to switching, and we are right on time, so we're good. We are now going to turn to the estate planning, powers of attorney, different planning for continuity. And for this section, I'm very happy to introduce my friend Pablo Palomino. Now, Pablo and I go way back. Actually, no, it was just yesterday that we were in law school together, and he was a 2L in that great La Raza class of 2002, and were great mentors to us 1Ls. So anyway, but since that time, the more important thing is that Pablo founded his own estate planning and probate firm, Legacy APC, and that firm has the goal of helping each client from first generation immigrants to people whose grandparents and great grandparents were born in this place, to help everyone equally realize their American dream. Pablo,
Thank you.
sorry, go ahead.
Good. Thank you, Maria. Thank you to the leadership that organized this very timely, important conversation. It's an honor, privilege to be here. In spite of my youthful picture in the prior slide, which is 12 years old, I need to update that. I've been doing estate planning for 23 years. Two stories. One, I am a beneficiary of amnesty. I came to America in 78. My father had an order of deportation when amnesty became law. So we were on our way out. This hits home in a very personal, real way. I remember the phone call. My dad was moved to El Centro, and I didn't know what was going on. Mijo, dile a tu mamá que me agarró la migra. And I thought, what? I learned more than I ever cared to know about that process. Second story is I live a few blocks down the street from Buona Forchetta here in San Diego. So recently in San Diego, there was a raid at a restaurant. The community sort of stood their ground. And we were just there the day before. We're doing dinner today. So it's all around us. This is not just about folks who are facing imminent deportation. This is about all of you in this conversation. The material here applies to each and every one of you. So the way I think ultimately to really absorb the tools that I'm going to discuss is consider, what does this mean for you personally? So if you imagine in your world, if I am at a loss of control, which is what we're talking about, how is there continuity in my life? When we look at continuity, we're looking at assets, continuity in asset management, continuity in people, caring for elders, minors, caring for other financial affairs and other affairs, pets, etc. So continuity is the name of the game here. So what we try to do in continuity is establish really clear framework to survive that a principle is absent or incapacity. By the way, if anybody wants my speaking notes, I'm happy to make those available to you. It's 9 pages of speaking notes because that way you're not having to take notes. In continuity, we also want to create some degree of redundancy. So if plan A doesn't work, we want a plan B, we want a plan C. What we want to do is minimize the risk of court intervention at all points. Conservatorship proceedings, court proceedings, as you well know, are costly and time consuming. So what we want to do is plug those gaps. Okay. Let's go to the next slide. The durable financial power of attorney. The California Probate Code, as you see there, section 4000 to 4545 governs the durable power of attorney. California has not quite adopted the Uniform Power of Attorney Act, but it has a significant influence in our statutory form. There are essentially two durable powers of attorney. One is an immediate power of attorney. The other form is a springing power of attorney. The immediate power of attorney takes effect immediately upon execution. Um, it's important to note that even though the principal may appoint an agent to act on her behalf, the principal continues to retain a concurrent authority. The springing power of attorney becomes effective upon the principal's incapacity. And incapacity can be defined in any number of ways. It could be defined by two doctors' letters certifying loss of capacity. It could be defined as a court determines the principal incapacitated. It could also be defined as a person incarcerated or in detention. The the springing power of attorney variety might not be ideal for our immigrant families because it becomes very difficult to prove that the principal has lost the capacity to act for herself. So in our context of crisis, it is probably prudent to have your clients and people around you execute the immediate power of attorney because it makes for easier implementation in the real world. Scope of authority. What can an agent handle on behalf of the principal? Bank accounts, investment accounts, uh, credit card liability, real property transaction, sales, purchases, leases, tax matters, including filing returns, personal property management, vehicles, for example, business operations, gardeners, construction workers. A lot of our immigrant families are quite entrepreneurial, so there's a significant management of affairs if principal is not able to manage those affairs. The statutory form is, and we'll look at it here in a second. We'll walk you through the form. Is quite broad and sweeping. The statutory form, also allows for enhanced powers in case someone has unique affairs that need to be managed by an agent. Regarding the execution of the form, the the statutory form is widely available and free. I mean, I invite all of you to Google statutory California durable power of attorney, and you're going to find great many websites that provide fillable forms. To the extent that you're helping people execute this document, you want to stick to the statutory form. You can,
Pablo, would you like
yes,
me to go ahead and click on it?
yeah. Let's go into the form. I think a picture is worth 1,000 words here, right? So let's
Okay,
look at the
if
form.
it'll let me. If it'll let me.
Yeah,
It did it
and
in
you
the
will,
practice, but
yeah, and you will find that the form is not complicated to fill in. It's quite turnkey ready. Um,
mm,
the the statutory form.
you have it here.
There we go. There we go. So I want to highlight here okay. So there you see I fill in blank appoint agent language there. And then I usually have my client's initial letter N. Initializing letter N would allow the agent to act A through M. And down at the bottom, you see that there's space for additional powers that would extend beyond what's enumerated here, or maybe there's a specific transaction that needs to be that is not quite enumerated there. The best practice is to have the form notarized. The form can also be executed by way of two witnesses, but oftentimes you will find pushback by third-party institutions if the form is not notarized. The other pointer here is that oftentimes third parties will fail to recognize a copy of a durable power of attorney. So the best practice is for the agent to present the original. Copies are as valid as originals, and oftentimes we find ourselves having to write nasty grams to third parties that are refusing to recognize the power of attorney. The point here is that you want your clients to have their signature notarized because the ritual of a notarization adds to the solemnity of the event. It signals to the third party, if you will, the seriousness of the document. Regarding the agents, the let me see here. I have a note about our agents here. Okay, so your agent, the agent of the principal must be at least 18 years old. They must be mentally competent. And there's no legal disqualification. So if the agent might have some kind of criminal record, that doesn't disqualify the individual. Okay. So that is the durable power of attorney. As you can see, it's broad, it's all encompassing, it's quite sweeping, and it's just something that I would call to action that in your intake process, everyone should have the form before they leave, execute this form before they leave your office. I mean, like every living person should really have this document available because we're human beings. Let's see here. A couple of other points that I want to highlight here is that the agent is a fiduciary, right? So the agent has a fiduciary duty to the principal. That means that the agent has a duty of loyalty, has a duty of care, has a duty to account. And if the agent breaches their fiduciary duty, they're potentially personally liable for breaches of the duty. I think I have more information on the following page, the following slide, Maria. Okay, so revocation. Written notice to the agent is required. And if the form has been provided to institutions, it would be recommended that the relevant institutions also be advised that the power of attorney has been revoked. Ideally, the original document is also destroyed when it is no longer necessary, right? And I feel that these forms are always necessary. If anything, these forms might need to be updated. There are certain events, triggering events that automatically revoke these documents. The death of the principal terminates the authority immediately. If the individual appoints the spouse, depending on the language of the document, the divorcing spouse's authority is revoked. Okay, so let's hear pitfalls. As you can imagine, the agent steps into the principal's shoes, so they can virtually wreak havoc on the life of an individual if they abuse discretion. So some tips to address pitfalls might be to appoint co-agents to act on behalf of the principal, requiring that both agents must sign all documents and act concurrently. Of course, there's a practical consideration, and the tasks become that much more burdensome because it's two people acting. However, it's choosing. So I think that's all I want to say about pitfalls. The next instrument that we want to talk about here is the medical directive, right? So for the medical directive, previously known as the living will, the advanced healthcare directive, the medical power of attorney, Probate Code 4600 to 4806 establishes the framework for the document. There's 4 essential components to the medical directive form. So the healthcare agent has primary authority to make full decisions regarding the principals, their body, their organs, end of life. The form itself, maybe we look at the form here. Actually, pictures there we go. Okay. This form can be also fill in, also widely available. Also allows for the principal to appoint multiple people in succession. So there's a first agent, the second agent. I like 3 deep wherever we can get three deep. There's more pages on the form, yeah? Yeah. So here, Advanced Healthcare Directive Form 1.5, post-death authority is where the individual would indicate cremation, burial. The form also allows to specify medical treatment preferences like pain management and comfort care, artificial nutrition, hydration, life-sustaining treatments and decisions. If we go to, part 3 of the form is back one. Part three of the form is where the principal would indicate regarding anatomical gift provisions. You want them to be consistent with the DMV donor registry, specific instructions there for donation procedures. And we naturally, we always consider religious and cultural considerations. Okay, disposition of remains, we talked about that. Executions, is there a second page here? Let's see, yeah. Similar, this document can be witnessed. My preference is always the notarial process because again, it adds solemnity, and then we also have an official record in a notarial book that is accessible to third parties. It's enhanced legal security. It's just a best practice whenever possible. Um, um, Agent qualifications and restrictions. The doctor, obviously, care providers cannot serve as medical directive agents. It's typically a relative. It's typically a friend. Regarding revocation, we can go to the next document. Yeah, the next slide. One more. I think a lot of my talking points are there. Let's see. Revocation of the document. Okay. Similar to the durable power of attorney, notify all relevant healthcare providers and institutions, retrieve and destroy copies of the instrument. Some considerations, obviously, consider the agent's physical proximity to the principal, to medical facilities. Consider the agent's ability to come into the States. Consider the agent's ability to adequately communicate in English. Wherever possible. Let's see here. I'm going to skip all that in the interest of time because I want to make my notes available to everyone. Let's go to the last slide, slide 6. Best practices. Okay, stick to the forms. The forms are there for a reason and they work. They're widely recognized. That's a tip. Some practitioners will want to modify the forms. Just don't. Complete all sections as complete as possible. Try to avoid leaving blanks that could create ambiguity. I like to use blue ink to distinguish copies from originals, but black or blue ink is fine. As naming conventions, it's always interesting in my world where we have. So being here close to the border, I have a lot of Latino Spanish speaking clients, and it's always an alphabet soup of names. And then oftentimes we have people that have borrowed identities. So naming conventions throughout your documents is really, really important. The storage of documents, that's always difficult, right? And I think the best practice is to have an emergency preparedness folder somewhere, right? A folder where the individual compiles critical legal documents in a portable format, IDs, directives, powers of attorney, emergency contact information, and then the individual would want to create multiple copies of the emergency preparedness folder to make it available to decision makers. Resources, again, the forms are widely available. They're free. All of you on this call should download a form, become familiar with it. They're really accessible. Always happy to help answer any follow-up questions. And with that, I pass it to my colleague to speak about other forms.
Yes, and Pablo, by the way, before I introduce Teresa, they're also all available in Spanish, correct?
Yeah, I mean,
I think we have some that we're giving people.
Yes, so the Spanish language forms are excellent so that the principal fully comprehends the nature and scope of what they're signing. They wouldn't be the forms naturally that would be used in the real world because they would be unrecognized. But yeah, all of these forms are, and if not, then we have very smart AI that can translate documents effectively for people. So.
You're going to say we have very smart friends.
We do. They just don't have heartbeats.
All right. Well, Thank you, Pablo, for that. And yes, I want to now introduce Teresa Gutierrez, who also is a very dear friend. I'm happy to say that I was there when she started her own practice because she was a member of our 2017 LA Incubator Consortium cohort. And today she has her own law firm and she does all kinds of estate planning, especially for Spanish speakers, to make sure that they can protect their assets and, of course, their kids and even their pets we'll go into. So Teresa.
Hi, everybody. Thank you so much for being here. Thank you, Maria, for that introduction. I mean, what a powerhouse here from the organizers, Luz, Maria, all the amazing bar associations, the panelists, and certainly all of you participants here and everybody in the chat, bringing all this brain power. So grateful to be here. And I mean, amazing foundation and context laid down by both Michelle and Lisa. Thank you for that. And thank you to Pablo also for getting us started on this very important estate planning conversation. And as he noted, how we could protect not just ourselves, but definitely our community right now in dire need of, defending what's theirs. So I think our end goal today is that we all leave just hopefully, fearless, focused, and forward, right? We're not going to be overcome. We're going to rise. We're going to come out of this together. So without further ado, I'll get started here. But before I get into how to get into planning for the caregiver of a minor in the event of an arrest, a deportation, or removal, I just wanted to highlight some points that Pablo noted on the financial power of attorney and the health directive, because I think that's going to transfer over to this segment of the conversation, which is namely that when given the option between simply signing or witnessing and having a notarized signature, definitely go for the notarization. While the notary does not verify the contents or validity of the documents, certainly they're there to verify identity, which is super important, I think, in these cases. Okay. Secondly, I think very important, as Pablo noted, we do have some of these documents that are referenced today in Spanish form for you in the wonderful folder put together by the San Fernando Valley Bar Association. So definitely reference that if you're helping folks, because you do want to make sure they understand what they're signing. But we prefer to sign everything in English, right? Because that's going to carry weight and validity. So I just wanted to point those two things out before we get going here. So, what happens with our children? So in my 10 plus years of estate planning, this is often a very hard conversation to have with folks, because it's just really difficult to sit there and contemplate, one's potential absence and who's going to care for our kids, the other, because no one is going to do it like us, right? Like a natural parent would. So it can be a challenging conversation to have. But like Pablo said in his segment here, really what we're trying to do is minimize court exposure for our community, right? We're not trying to hit like the nuclear button and go to court. We're trying to implement and institute these documents and instruments that can be used, the least restrictive means, if you will, outside of going to court, before any type of court proceeding is potentially necessary. So that's definitely going to drive my section of the presentation here also. So what we're going to cover in my segment, and I do realize we're heading on the back end of our presentation here, and I'm going to be respectful of everyone's time. And as all the other presenters have already noted, we're all available to send information to you directly or answer any questions you might have. But I like to think of the caregiving of minor children kind of on a continuum, if you will, right? Very informal proceedings on our far left, and then on our far right, we have things that are more formalized, like a legal guardianship that requires court proceedings, potential adoption, right, which we're not going to cover here. But you could think of it on a continuum. So I would say, step one for all of you very able and capable individuals working with our community and having these challenging conversations is hopefully if you can help whoever you're working with narrow down kind of their top choices of who they would want to care for their children in their absence. Like Pablo said, if you could get 3 deep, that's really good. That's usually what I recommend for my folks if possible. But you know what? Sometimes we only have 1 or 2 people. And if that's it, so be it. Every now and again, I get a longer list, 4, 5, 6, different tiers of potential caregivers. But once you've overcome that challenging conversation of who would maybe step into your client or community member's shoes to care for their children, well, then the next step is hopefully having them organize, for each child, maybe, a list of kind of what they need to function, daily. What school are they going to? What medication, if any, do they have? Doctors, dentists, that type of thing. Really without overwhelming them. And I'll probably reference them a few more times throughout my conversation here, but I would highly recommend looking up Betzedek. Most of you have probably heard of them, BET, and then TZEDEK, Betzedek, wonderful nonprofit out here in the Los Angeles area. Actually, if you just do a Google search, Betzedek Family Preparedness, a packet will come up. And what I like about this packet is it has a one-pager, and it's in English and Spanish also, of just kind of the most pertinent information that a caregiver might need for your child: date of birth, phone number, schools, medical condition, allergies, doctors, family contact, just a snapshot, right? We don't want to overwhelm folks. So I would say get something of that nature filled out, or just a simple notepad. As a precautionary measure, I often tell people, try and digitize this too. If you've written it down, with our smartphones these days, we have scanning abilities, get it scanned, put it in your email so that you can easily, forward it or text it to whoever you might need on short notice. Okay, so once your individual has done that, then we want to start thinking about forms, right? Forms and documents that we could fill out, that we can have notarized potentially, to leave these caregivers behind and our children behind in the best position possible. So next slide, please. Right. So in addition to filling out the form, I would say, depending on the child's age, consider having the child, and of course yourself, memorize your top choices, name, phone number, maybe address, right? In addition to that, you're going to want to consider updating or reviewing your emergency contact lists at your children's schools, and other activities that they're involved in. The reason being, if the individual is detained or taken into custody while the child is at school, or while the child is at an extracurricular activity, what we want to try to avoid in an already stressful situation is a child spending any time in the foster care system or DCFS, as we're working to maybe get them connected with this long-term caregiver, right? We want to minimize that. So what I tell people is, okay, maybe on the emergency contact list, let's say your primary caregiver is in another state or a few states over. So it's going to take them a moment maybe to get here. Well, maybe on these emergency contact forms with the schools and extracurricular activities, we're going to consider putting people down, like our neighbors even, of course, after having conversation with them, making sure it's okay. Why? Because we'd rather our children be with the neighbor, maybe a few hours, a couple days, as we're waiting for that caregiver to make their way to California or wherever the children are at. So that's kind of a more short-term plan, okay? Next slide, please. Okay, second to all of that, we would like potentially the parent and the caregiver or the caregivers to contemplate pre-filling out this California caregiver affidavit. You're going to see that there's a link here provided for that. It's in the resources, similar to the statutory forms that Bob will reference on the financial health directives and health care directives for people 18 and over. These forms for minors are also widely available at the court website. So we would recommend using these, and our lovely nonprofit that I mentioned here, Betzedek, also has it embedded within its packet that you can confidently refer to. But what's beautiful about this caregiver affidavit, because a lot of folks are often concerned about, giving up their children, so to speak, right? So the caregiver affidavit it's not court. It's very informal, right? And it's based on the California Family Code, Section 6550. The Education Code is also triggered here, specifically. Let's see, I have it right here. Give me just a moment. Education Code 48204 is also triggered here. But again, the beauty here, so a lot of people might be worried, parents, and say, hey, if my caregiver fills out this form, am I giving up my child forever? No, absolutely not. This form is not even a legal guardianship, much less an adoption. And this form does not suspend parental rights. So this is kind of this nice middle ground. Remember, if you think about that continuum of caregiving for a child, informality, formality, this is heading more like toward the middle, right? So the parent doesn't even need to fill this out. So consider, for the folks that you're working with, maybe printing some of these out and saying, hey, Teresa, for example, if you're before potentially getting arrested or detained or removed, consider sitting down, having a conversation, with those close to you, your village, so to speak, and who would step in and care for the kids. Consider leaving them with copies of this affidavit. Pre-fill it out, don't date it and sign it yet, but pre-fill it out just in case they need to step in and care for the kids. They have this ready to go. And guess what? It doesn't even have to be notarized. The caregiver here signs it, not the parent. And it's signed under penalty of perjury, of course. And it's very simple. You'll see here, Maria put up on the slides, the left side is the actual form. So it's 1 page. And then what comes after it are instructions, right? So the upside here is it's not a court proceeding. The parent's not giving up their rights. The parent doesn't even need to sign. It doesn't even have to be notarized, right? So that just elevates the simplicity of getting it done. And there are Spanish versions of it, right? The downside is you'll see here in the instructions maybe that for someone to fill it out, for a caregiver to fill it out, they have to be a qualified relative, right? So usually that means someone like a grandparent, an aunt, an uncle, or another qualified relative, such as like a step parent, a stepbrother, stepsister. So it does expand a little bit more, half sister, or any person denoted by the prefix grand or great, or the spouse of any of those persons. So it can include quite a bit of folks, but there might be some limitations, right? But once a caregiver, so if I, Teresa, fill this out because I'm caring for a niece or a nephew, let's say, in the absence of a sibling or a sister-in-law, a brother-in-law, that type of thing, what is this form going to allow me to do? Well, in essence, once I fill it out to take care of my nieces and nephews, I'm affirming that I have physical care, right, of the child, and either that the parent has somehow given me authorization, depending what I check here, number 6, or that I'm unable to, in good faith, reach them, right? I'm going to put my date of birth. I'm going to put my California driver's license if I have it. If I don't have it, not a problem. I've helped plenty of folks without status fill that out. And the instructions simply say, hey, if you don't have a California driver's license or a California ID, just provide another form of identification. So I usually write in the card info, and then I'll sometimes take a copy of that ID and attach it, digitize it, and then give it to the caregiver so they have it electronically. I have it electronically, and then I leave them with the originals, right? So like Pablo said, document storage is very important. The beauty of a lot of these instruments that we're touching upon this afternoon is that digitized copies carry the same legal weight as the originals. So I think it's very prudent to have them digitized, right? We could have emergencies where documents are destroyed, misplaced. So what better than to have it digitized? So that's the caregiver affidavit. And what this is going to allow, before we get into the minor power of attorney here, is the caregiver affidavit, for the most part, will allow the caregiver to do some fundamentals, such as enrolling the child in school, and or even some medical care, right? So again, it's the least restrictive means. That's where kind of we want to keep people, if we can, because it keeps them out of court, and it keeps parents, from that very dreaded thought of completely signing over custody to someone else. Okay, so that's the caregiver affidavit. Next, we're going to get into a little bit here, a California minor child power of attorney or medical authorization. So think of like what Pablo was already discussing, that an adult that is 18 or over might sign for him or herself, as Lisa put into context for us, right? Some of our community members are business owners, property owners, and in a moment of being swept up in this chaos that's happening, there might be an immediate need to terminate a lease, or so on and so forth. The reality is that in addition to the 18 and over person having these needs, the minor might have these needs. The issue is that the minor cannot contractually sign anything, right? So in addition to, I would say in addition to, not necessarily in lieu of, the caregiver affidavit, which is the most simplest of all these instruments to execute, consider also a power of attorney for the minor. We have samples there for you. On the most basic level, it's going to list the minor's name, the date of birth, or it might generally say, hey, such and such agents can care for any minor child of mine if I'm unable to, right? There's many ways to do it. I would recommend, and I should have said this on the caregiver affidavit, it should be one form per child. Okay, so back to the caregiver affidavit, if you have 2 or 3 minors whose care is in question, make sure that your community member fills out one of those forms for each child, even if it's going to be the same person, just to keep things clean, orderly. Similar here in the sample we've given you, you would have your community member fill one out for each child. And these powers of attorney, you can look at it more thoroughly in the materials, but it's going to let your agent or the attorney in fact that you've listed, in XYZ order, if you've hopefully gone 2 or 3 in, as Pablo already noted that we should, do pretty much step into your shoes and do for your child what you would be able to do for him or her. Maybe access communications intended for your son or daughter, communicate on his or behalf via mail or electronic transmission, telephone, or other means to determine your child's residence and domicile, to deal with your child's property as you would, right? Including purchasing, selling, or taking possession of the property. Again, we're trying to be expansive in the powers that we're giving our agents. Why? Because we're trying to ward off court, right? At all costs, if we can. And court here, whereas Pablo's instruments would trigger a conservatorship for someone 18 and over, here for our young persons, minors, guardianship of the person or guardianship of the estate is potentially triggered if these instruments fail. Now, I think Pablo touched upon this, a few people in the chat boxes. Ultimately, yes, it does fall on some of these institutions if they push back or not. Sometimes they send these documents up to their own legal department, which is sometimes housed by lawyers, staffed by lawyers. Sometimes it's not. So you might be facing some sort of resistance, but I've had plenty of clients, community members rely heavily on the caregiver affidavit and not need a guardianship. And then some, because the child has had more kind of special needs, have necessitated a guardianship, right? Because it's more long-term. And the caregiver affidavit doesn't really let the caregiver sign or authorize anything that requires parent or guardian, hence the terminology parent or guardian. So that's usually where we see sometimes limitations, right? I can tell you personally, I've used one of these before when I had a minor health situation that I was dealing with, and I couldn't personally take my child to a health commitment, a very important health commitment she had. I, did a little power of attorney, and it worked just fine with the doctors. And I sent my family to be able to care for her. So these instruments, will work, but just understand that there might be some limitations depending on the child's specific needs, or there might be some pushback. And that's maybe when you as an advocate, might have to make a few phone calls or send a few emails and reference, parts of the probate code or the family code or whatever it may be, the education code that says that these type of instruments are okay. And that might be enough sometimes, right, to overcome it. Again, keeping our community members out of court if we can avoid it. So again, these instruments are there for you in the materials, and we want to be very careful. I always say, I've seen it all, we don't want people putting their kids on deeds of property or on accounts, because that's a fast track ticket to have to open a guardianship of the estate, right? Because the kids cannot manage these things. So we would hope that they, talk to all of you first or a professional to avoid those type of headaches if we can avoid it. Okay, perfect. Next slide here. So traveling outside of the United States, this might be triggered under these emergency scenarios that our community members are finding themselves in, right? Mom or dad might be in their home country out of the US, or heaven forbid, somewhere that's not even home, based on what we heard from both Michelle and Lisa, right? It's terrifying. So there might be a need for mom or dad or both to authorize XYZ individuals, their caregivers of choice, to travel with their children, right? Domestically or abroad, but more specifically abroad. So this form that we have in the materials for you would give mom or dad the ability to make this authorization, and importantly, to have it acknowledged by notary public. What you should know about these documents here is that, similar to everything else we discussed, it should be one per child. And then it is specific to the travel in question. So if they're going to be traveling late June or in August, it would cover that travel period. If there's another travel period required later in the year, a new form should be filled out, if that makes sense. That's why we have the dates here describing the nature of the travel. Okay, so that's in your material. So this issue, from what we heard, I haven't dealt with it personally yet, but it's become an issue. So we want to make sure that our community members are prepared, and at least maybe have these forms on standby for if they become necessary. Next slide, please. All right, finally, so I told you, caregiving, think of it on a continuum, right? So we're hoping to keep our folks out of court if we can avoid it, because the informal documentation and processes are working well. But mom or dad, or both, subject to potential deportation removal, might want to consider doing a guardian nomination, right? In addition to all these other forms. What is a guardian nomination? Well, if it becomes necessary to formally file a legal petition in probate court, which is where we established California guardianships, it can be helpful. It's not necessary, but it can be helpful to have the benefit of mom or dad's thinking about who they would want to be formal guardians for the kids. And that's where this form comes in. It's a judicial council form. It could be attorney drafted also. I don't think we have it in the materials, but I'm happy to provide any of you.
Here it is.
Oh yeah, perfect. Yeah, so this is our guardian nomination. And really the focus for nomination by mom or dad should be right in the center, items 2 and 3. I'm a parent of minor. I nominate, and then right there, you would just put the name and address of the person nominated as guardian of the, and you could check off person, estate, right? Person would be managing day-to-day care, health, where the child lives, education, estate of the minor, that maybe the minor is coming into an inheritance or something like that, or the minor was listed on some sort of policy or whatever the case may be. And we need a guardian to manage both of those things, the day-to-day care and the finances, right? So the guardian nomination is just really strong, because sometimes what I've seen in an emergency situation is multiple people petitioning to be legal guardian or guardians of the children. So that will sometimes draw out and elongate the.
Uh-oh, Teresa, I think something happened to your microphone. Let's I'm gonna skip to we'll wait for Teresa to come back, but I'll skip to this one because this was my slide. The durable power of attorney for pets, just to flag that there is a form for it. Here's Teresa. She had accidentally dropped off. So I'll just cover that slide and just say that don't forget our furry friends. And yes, that is my dog. Okay, so now we got that part over with. Teresa, are you back?
I am. I'm so sorry. The connection just dropped there. But yeah, I was wrapping up anyway. A guardianship nomination is just there in case a guardianship is needed. It could be super helpful, but that nomination in and of itself does not institute the guardianship, right? You still have to formally file. So the reality is, folks, even if mom and dad is out of the United States, in home country or somewhere else, heaven forbid, that form could still be signed digitally, right? So don't fret if they don't get it done before any detention or deportation. But yes, carry on, Maria, please, with caring for our pets too, also members of the family.
Well, no, go ahead. I was already done. So
okay. Yeah. Well, this last
we're on
slide
the
here.
IEP. Mhm.
Yeah, this last slide here, is not to suggest that anyone here should draft a special needs trust or anything like that. But if you come across community members that have children with special needs, be it IEPs, individualized education plans, right? Make sure that they get all that documentation ready. In paper and also digitally for the potential caregiver, right, to kind of create the seamless transition, if you will. And then if the child is also maybe receiving public benefits or some sort of special needs, oftentimes what I have seen is parents say, oh, my son or daughter was born with Down syndrome. I'm just going to completely leave them out of any estate plan or planning, which can be detrimental because if mom or dad are gone, those kids are in theory unprovided for, right? Or worse yet, the children are receiving public benefits. And if they're named as beneficiaries, the very fact that they're receiving an inheritance might invalidate those government benefits, right? So if you come across someone like that, just think, okay, maybe we're treading in special needs territory. Maybe mom or dad or both should speak to an attorney that does SNIDs, or there's pooled trust. There's a lot of resources out there to protect the special needs child. So just think about that in case you come across it. Thank you.
Amazing. And then just as we said, yes, because you don't want your pet to end up in the overcrowded animal shelters, you can do this durable power of attorney for pet care so that you can have someone you trust be nominated to take care of our friend. Now we have just last steps and closing. One more, last but not least, Walter Quinteros, and he is the president of the Board of Community Lawyers, a wonderful nonprofit in Compton. Walter, are you here?
Yes.
All
I'm right
right.
here. All right. Good evening, everyone. Thank you for being here and for all the great information that we received from our speakers. So let me just get started. To close out, we kind of wanted to discuss with everyone some of the ethical considerations that we should keep in mind while doing this type of work. And I know that after hearing all that information, you may feel like, oh man, I may not be qualified to do this type of thing. But I do want to point out, starting off with Rule 1.1 of the State Bar, of how it defines competence and how you can achieve it, right? So it tells us that simply by consulting with another lawyer who has the competence and also acquiring the sufficient learning skills to perform this type of work, you are competent. And in the later slide, I'm going to discuss some of the resources that exist out there to gain that confidence. But the point of this being is don't be scared, don't be deterred if this is a lot of information. There's a ton of resources, including ourselves over here, to try to help everyone to go out there and perform this important work for so many people that need it at this time. Okay. You can go to the next slide. Thank you. So some other ethical rules to keep in mind while doing this work is things that we kind of talked about earlier, but are kind of outlined through the rules of conduct: limited scope, advising and assisting in violation of law, professional liability insurance and disclosures, duties to prospective clients, responsibilities regarding non-lawyer assistance, and limited legal services programs. Okay. So I want to talk about a few of these that kind of stand out. Okay, so we can go to the next slide, Maria. Thank you. Focusing on malpractice insurance. When we look at malpractice insurance, most of us have them, and most of our malpractice insurance do cover pro bono work. Okay. Now, if you don't know whether yours does or doesn't, a simple phone call and you can find out that information. But if you find out that your pro bono work is not covered, there's other ways you can go ahead and get covered. Find an organization. If you join up an organization, work under a supervising attorney, their malpractice insurance may be able to cover you while you do this type of work. So don't feel limited if you just feel that, or if you don't have malpractice, or if your malpractice insurance doesn't cover this work. Limited scope agreements. This is very important. It sets the tone, not only protecting yourself as to what the scope of your what you're doing for the client, but it also tells the client what it is that you're doing, what it's limited to, and it'll let them know, like, maybe, okay, after this, what other steps they have to take to kind of fully implement or prepare for the next steps. So it just helps. It's always helped to have a clear understanding of the relationship between yourself and the client. And the availability of a notary or witnesses. So I know we heard earlier, a lot of these documents don't necessarily require notaries, but it's best practice to have that. And so there are a lot of different resources to obtain a notary. most of what I'm trying to pitch to everyone is, phone a friend, talk to a friend, look into your network, reach out to people who may have notaries. I've talked to some that are excited to kind of donate their time as much as they can to help, in these type of processes. And so they're out there. Notaries are out there. Seek them out, find them again through NGOs or different organizations. You can find them. And something I want to point out is that on January 1st, 2030, there is a new law that goes into effect. It's a remote online notarization. So notaries essentially can be done digitally. Now, that doesn't go into effect until January 1st, 2030. However, the Secretary of State can fast forward that and start it earlier if they establish the foundation technology to do so. So just keep an eye out on that. We don't know if that's something that may pop out sooner rather than later, and it will be a great tool for us to look into and use. Okay. So resources, right? We talked about not feeling qualified, feeling kind of lost with so much information. Well, again, like I said, if you feel you're not qualified, reach out to your network, phone an expert, contact your local bar association, say, hey, look, I'm interested in this type of work. Can you link me up or connect me with someone that does it that can go ahead and guide me? Refer to obviously the materials that are provided. I know some of the speakers offer to share their speaking notes and everything. That all of that is great information that are gonna not only make us competent at doing this type of work, but also answer a lot of our questions that we may have. Also, we have the other resources at Immigration Legal Resource Center. That is a great website where you can go ahead and there's a ton of training and information that is accessible to everyone to go ahead and just kind of like start getting your feet wet and getting more comfortable with this information. Lastly, if you do feel comfortable and you're like, you know what, I'm ready, let's try doing it. But I kind of want to have, a little bit of oversight and kind of, dip my toes in the water. The Orange County Immigration Coalition has a sign up where it will help you, or it will start kind of linking you up where in clinics and such where you might be able to start doing this work. The QR code will take you to that sign up sheet. Feel free to sign up and just start it's a great way for you to start doing the work, not completely flying solo with some oversight. Besides that, I think that kind of concludes our the training for today. I know there was a lot of questions. If there are some of us may be able to stay on afterwards to answer some of those questions, but we thank you all for being here. We think that this is important work that opened up a lot of helpful possibilities for so many individuals that need it out there. So thank you again, and hope to hear from everyone soon.
Thank you, Walter. That was great. And yeah, so I think Linda from San Fernando Valley Bar is going to say something. Except
Thank you all. This was wonderful. I'm actually going to turn it over to Seth, who can say a few words. I know people want documents and so forth, and I think that'll be available on our site. And I think Seth can talk about that further. But thank you. You were all brilliant. And we so appreciate you taking the time, and we will coordinate this. And again, thank you. This was so important, so relevant, and it's what we need right now. Great job.
Thanks, Linda. And just want to say a special thanks to the presenters. Thank you, Maria. That was amazing kind of guiding us through this program. Everyone, take a look at the LA Incubator Consortium. Really cool program, super great. We will be adding all of the links and documents that are in the PowerPoint presentation to our resource page if you want to look at that. We'll have the PowerPoint presentation, of course, to circulate. And as always, let's keep this momentum going. We may have additional trainings like this, so stay tuned for that. And yeah, thank you all.
All right. So thanks, everyone. I don't know if any of the panelists had been able to stay and field any questions.
I
Maria,
can stay just for a few minutes.
let me post there we go. That's to sign up for the OC volunteers.
Great. Oh, and asking about the chat as well, if we can save the chat and circulate it. Yeah. All right. Well,
Circulate
I
it to
think
save it for reference for FAQs. You may not want to circulate it. I don't know if there's personal stuff in there, but it would be good in terms
sure.
of there were a few questions that kept coming up that could make great FAQs.
Excellent idea. So maybe if Linda and Seth could circulate it to Luce and I or to, the panelists, then we can kind of take some segments out.
Thank you so much.
Thank you, everyone.
Lisa, do you know which organization might have the checklist of questions to ask ICE agents? I mean, you probably don't really want to engage with ICE agents too much, but I think there are a number of organizations that have provided information in terms of warrants.
Yeah, there's tons of know your right materials, I would say. Chirla probably has some. I mean, there's a lot of options out there, to say the least. Yeah. And I believe, if I'm not mistaken, I think Chirla's doing something for businesses tomorrow, if I'm not mistaken. They'll probably have resources distributed there.
Go ahead and ask your question, Carla.
Hi. So I don't know. So the reason why how I found out about this Zoom is that currently I'm doing an internship. I'm in Los Angeles, California, with Judge Torrealba, and I guess you guys did an invite. I'm not an attorney. I'm nothing. So for me, all of this was new. I have three questions. Hopefully, this goes for anyone that could help me. Really. Um. So first of all, I work. Well, the reason of the internship is that I'm planning. I'm now slowly. I think I'm diving that I do want to become an attorney. Um, so currently, thank you. So currently, I'm working at an elementary school. I've been doing it for 14 years. So I think it's time for me to find a new career. And I was wondering, what information, if you guys could send me any information that I could share and give directly to my parents. I work at a school that is full, mostly probably the 95% are Latinos. And right now, I know they're having summer program. And one of my coordinators informed me that instead of having 60 kids, I only have 23. Do that they're scared to take their kids. And block away from that school, we had agents come and grab people. So they're not coming to the school no more. Is there any information that you guys could send me through my email so I could provide for parents? Because I took notes of everything that you guys said. I took notes because I'm here to support them. And thank you, Lisa, for all that information. I was like screenshotting everything like that because I couldn't write fast. But is there anything else I could provide to them?
So I would suggest that you scan the QR code of the Orange County Immigrant Coalition. We've been doing the Know Your Rights with school districts pretty regularly. You can organize a virtual, Zoom, webinar. We do have some resources that we can share, but get in touch with the coalition, and then we can help you through there.
Sounds good. And also, I have one of my staff that she barely turned 21 and she has been scared that now she's taking care of her two siblings. So she comes late because she needs to go drop them off, and she's pretty much taking the mom charge. And her parents are thinking of just deporting themselves. And she's scared because, she's barely 21. She's barely getting to know life. And it's like now she's going to become a mom. And I know she suffers with, she gets anxiety attacks. I know she suffers of that. I couldn't get because it was quick. The information. Is there like a way you could send me or write it on the chat where I could give her that information? Because I know sometimes she doesn't want to talk to her parents because they're scared, but to someone like to help her with that resource.
Yeah, so I'd say it's kind of tricky. Someone else had put in the chat, like I think there are nonprofit organizations. It's a matter of connect, like it takes a little bit of research, but it's really important that we get very familiar with the resources in our community, right? Because like I said, all the nonprofits are very, inundated in at capacity. I would start with the Catholic Charities or World Relief, out by you. There I would even ask the school district because they should have resources as well for like mental health and counseling that can be done, virtually. So I think you need to ask around locally. There isn't like a one, stop shop that can help everybody with all their needs. I think it's really about, and some of these nonprofits are restricted by geographical areas because of their funding. So it's always best to look for resources closest to where that person lives.
Thank you. And that was business wise. Personally, somebody could help me. So
Carla, I'm sorry. We can't do like a full consultation for all these folks that you know that need help. But I did post on their information where we're going to post this on the San Fernando Valley Bar Association website. And so if you email them to make sure that you have their that you have the information, that they have your information so you can get the email, that would be the best thing. But I can't. We can't continue to answer questions that are kind of specific to individuals for the purposes of this webinar. I'm sorry.
okay, so no, it's okay. It was just personally me, but thank you very much. I appreciate it.
Yeah, and I just want to mention, just be careful when you're in sessions like this. I really urge people not to share any personal information. We've had, I forget what you call it, people from the outside listening. So you never want it. You want to speak very generally about your questions. If I had a friend or so and so, but never ever disclose any private information on any public Zoom like this.
Thank you for that advice.
I also wanted to give a plug for the LA Law Library. So the LA Law Library is downtown and they also have a great website and they talk to anybody. So there's no restrictions. There are librarians, there are volunteer lawyers. So that's another good resource.
Thank you.
And I just put the information for the Chirla, I think it's Chirla and Cielo, that are hosting that Know Your Rights for business owners tomorrow.
Great. Well, why don't we end there?
Again, our special thanks. Thank you so much of giving your time and your expertise. Again, a lot of this will be up on the SFEBA website. And thank you all for participating. Wonderful. We'll end it there.
Thank you, Linda. Thank you, Seth. Thanks, everybody.
Have a good evening.
Okay, you too.